Good morning. Thank you very much for the invitation to be here and speak this morning. A few preliminaries. First of all, I want to say that I always thought that Bernie Lowe and I were good friends and that Bernie was a very nice guy, so I want to know why he only gave me 15 minutes to talk on something that's going to take at least 15 hours to do comprehensively. I asked him that, and he responded, it takes a maestro to condense to just the main messages. So flattery will get you somewhere, in my case, to Houston in July. Second, I want to thank some people. Tremendous debt is owed to people who are far more knowledgeable about POLST statutes and other aspects of POLST law than I. Amy Vanderbroek at Oregon Health Sciences, Charlie Sabatino at the American Bar Association, Thad Pope, another law professor, my former student and current co-author, Professor Kathy Sermonara, and my former student and always my teacher, Jason Mann. A few disclaimers. I'm a law professor, not a lawyer, so don't shoot me. I've never sued anybody, and I say this to sort of reduce the potential level of anger and defensiveness in the audience. Also, I want to say something about POLST statutes. Getting your hands on POLST statutes would seem to be easy, especially if you're a lawyer, but it's not that easy. Especially to get them all, to get them comprehensively. The ABA Commission on Law and Aging has a very neat table, which was very helpful to me, and it lists 20 statutes. However, there's 22. So I had to sort of dig around and find them on my own, and I want to say that I am pretty sure that there are errors in what I'm going to say, but I think I've kind of got the essence of what's going on here. So with that little bit of defensiveness off my chest, let me get going. If you've seen one POLST statute, you've seen one POLST statute. There is an amazing amount of variability among the forms and the statutes, probably because they use the Oregon form as a jumping off point, but there's also a lot of variability in the forms as well. So one of the recommendations I have, and perhaps the only recommendation, perhaps the only one that you'll take seriously anyway, is that I think an issue that needs to be addressed is that this issue needs to be addressed to the National Conference of Commissioners of Uniform State Laws, and that it be suggested that they draft a uniform statute on POLST as they have done in other areas of end-of-life decision-making, such as the Uniform Healthcare Decisions Act. There's no guarantee, of course, that state legislatures will adopt a uniform statute, or that if they adopt it, that they won't revise it in many ways so that you get the same variability or similar variability to what we have now. But I certainly think it's worth a try, because there really is an awful lot of variation out there, and there's some good points in some statutes that are lacking in others, and there's some really bad points in some statutes that ought to be removed. Of course, a lot of that is a result of the political process, and you can't get rid of it all. And I mean, variability is not necessarily bad, but it would be certainly a start, I think, in improving POLST statutes. Okay, so let me see. Okay, so this statute, or this slide has fly-ins, which shouldn't be there, but there they are. Okay. The first question that I was asked to address is the authority of surrogates to sign a POLST in states that don't have surrogate decision-making statutes. Now, surrogate decision-making statutes are essentially a hierarchical list of who's got authority to make decisions for a patient who lacks decision-making capacity, if that person has not appointed a proxy. There are, I count 51 jurisdictions. I'll use Washington, D.C. as well. So only 11 states no longer have, or still don't have a surrogate decision-making statute. And of those 11, 3 of them have POLST statutes. So we're really only talking about 3 POLST statutes here. And in all 3, the surrogate does have authority to execute a POLST according to I mean, it doesn't say that real clearly in all cases, but I think that would be my conclusion in those 3 states. So Bernie, I want to thank you for pitching me an easy one on the first question. The second issue had to do with surrogate override on statutes. Whether or not a surrogate may override or supersede a POLST that has been signed by the patient once the patient loses decision-making capacity. If the patient still has decision-making capacity, then it's the patient's decisions. But we know very often in these cases that people lose decision-making capacity, and then we turn to the surrogate, which is why we have surrogates. The statutes don't use the terminology override or supersede, but they use similar terms like revoke, modify, change, and I take them all to be roughly the same. 15 of 22 states permit this, though some have some qualifications, and the authority in 4 of the states is in the form rather than in the statute or regulations, and it would probably be better that it be in the statute. And that's another problem as well, is that a lot of the statutes don't really address a lot of the issues about POLST, and they're in the form. And it's not entirely clear whether the form has legal force behind it. So I would think that if the national commissioners or anybody else is going to propose a uniform statute, that the important aspects of POLST that go into the form also be described in the statute in a way that at least lawyers and courts, should it ever come to that, and I'll have something to say about that later and the utility of that, have to get their hands on these things and render some advice. Now, the qualifications in these statutes are that, you see them right here. In Delaware, a surrogate may revoke a POLST, but not in emergencies. In New Jersey, a surrogate may revoke a POLST, but only if the patient has, before losing decision-making capacity, authorized the surrogate to do so. Utah, the surrogate may revoke a POLST only if the revocation is consistent with the substituted judgment standard. Okay? So I think we know what the words mean, but how you actually apply that, of course, is another question. I was asked also to address the issue of POLST and, wait, let me see, I think I might wanted this, no, that's right, save that for later. To address the issue of POLST and nutrition and hydration. And what POLST statutes have to say about providing nutrition and hydration to patients. Well, POLST statutes, interestingly, have virtually nothing to say about nutrition and hydration, which I found very interesting because this is has been a very controversial topic historically, and I don't see, I know that it still is, at least in clinical settings, if not legally speaking, but I think it is. Rather, it's the forms that have the information about nutrition and hydration. So all POLST forms do address the issue, and most require that oral nutrition and hydration be offered to all patients, some adding if medically feasible. Some implicitly require this by virtue of language, that comfort measures must always be provided, and all of the forms offer choices about the types of nutrition and hydration and the circumstances under which it's to be administered or withheld by checking a box. Either the patient or the surrogate, whoever completes the POLST form. Now, I was also asked to address the similar issue in other forms of advanced care planning, which would be advanced directives and surrogate decision-making statutes. So first let me say something about advanced directive statutes. At one time, a considerable number of advanced directive statutes prohibited the foregoing of medically supplied nutrition and hydration. However, as the case law, really after the Cruzan case in 1990, has become virtually unanimous in accepting the proposition that decisions to forego medically supplied nutrition and hydration should be treated no differently from decisions to forego any other form of life-sustaining medical treatment. Advanced directive statutes have been amended in most states to reflect this development. And today, most statutes are silent on the subject, or they require you to check off a box, whereas they don't require you to check off a box with respect to other treatments. So in 12 states, the statutes allow the foregoing of nutrition and hydration only if the patient has specifically refused them by checking off a box, or the patient's wishes regarding them are reasonably known or can, with reasonable diligence, be ascertained. In another 12 states, well, I shouldn't say another because there's probably some overlap here, the statutes prohibit the foregoing of normal feeding procedures, the use of a cup, spoon, baby bottle, drinking straw, by excluding them from the definition of medically supplied nutrition and hydration. In 11 states, the statutes specifically permit proxies to authorize foregoing of nutrition and hydration if they believe the decisions are consistent with the patient's desires, and of course if the patient lacks decision-making capacity. Most statutory provisions limiting the foregoing of medically supplied nutrition and hydration require that it be provided if it's necessary for the patient's comfort, and statutory provisions prohibiting the foregoing of medically supplied nutrition and hydration might be unconstitutional after the Cruzan case, but nobody has really tested this, and I don't really see a test of it coming up anytime soon, but it is at least a theoretical possibility. Surrogate decision-making statutes and nutrition and hydration. No states prohibit a statutory surrogate from foregoing nutrition and hydration. Now, statutory surrogate is a person who becomes a surrogate by virtue of law, not by virtue of being appointed by the patient. So this is in the absence of a proxy appointment. And 5 state statutes contain specific guidelines for surrogates to follow in making these kinds of decisions. I was also asked to address the issue of physician refusal to honor POLST. And I thought that this would be a front and center topic, and it turned out that it really wasn't. There are really a few questions embedded here. The first is whether a physician may refuse to co-sign a POLST that has already been filled out, signed by the patient or the surrogate. Second is whether after a POLST has been co-signed by a physician, another physician, or indeed, I suppose, the same physician that signed it, may decline to implement it, and if so, on what grounds. And a closely related question is whether if the physician intends not to follow the POLST, he or she has an obligation to assist the patient in obtaining alternative medical services. Okay, first, the physician refusal to co-sign a POLST. I was able to find only one statute that addressed this issue at all, and the Nevada statute states that upon the request of the patient, the physician shall complete the POLST form based on the preferences and medical indications of the patient. Now, that's not the strongest indication that the physician must sign the POLST. It says shall, and shall usually means must, but I could find case law very easily that says that shall means should. I never use it that way, but in any event. So it looks like physician must. To the extent that the statutes address the issue of physician noncompliance, they focus on the second issue. They assume that a POLST has been issued, that it's been co-signed by a physician, and then address the issue of whether another physician may decline to implement it, and if so, on what grounds. The statutes here are surprisingly silent or oblique on what really should be a key issue. Only 12 of the POLST statutes have provisions, and 3 more have statements in the form that directly address the issue, and they require physicians to comply with a POLST, or to comply or transfer, or assist the patient surrogate in arranging a transfer. West Virginia form even states it's the responsibility of the surrogate. It goes so far as to state it's the responsibility of the surrogate, not the physician, to arrange for transfer, and says that the healthcare provider shall cooperate in facilitating such a transfer. So that's pretty weak. Some provide exceptions, such as suspending the duty if the treatment would be medically ineffective, the duty to comply with the POLST, if the treatment would be medically ineffective, or not complying with it, but they may update the POLST to reflect the patient's changed medical condition. So a physician doesn't necessarily have to comply, but may update the POLST. A few states, but surprisingly few, expressly state that the basis for doing so may be the physician's conscience or moral beliefs or religious beliefs are similar. I thought this was going to be all over the place. There's going to be provisions in all these statutes saying if you were conscientiously opposed on religious grounds, moral grounds, whatever, to implementing the POLST, you didn't have to. And I didn't find that. 5 of 22 states, I think, had that. Most of the forms contain a statement like this, the forms. First, follow these orders, then contact physician. Now, does that create an obligation on the part of the physician to follow the POLST? I don't think so. I think it's just instructions about what the POLST is. First, follow the POLST, then contact physician. So, I mean, this is the kind of stuff that you find in the statutes and the forms, and not entirely sure what to make of it. I don't have a slide on this, but I was also asked to comment on the case law, whether there have been any lawsuits involving POLST. And there have been a few, not very many, and the ones that I would take seriously are the ones involving an obligation to comply with a POLST. And they have not been for damages. They've just been to try to get a court to order a physician or a family, whatever. And they've been pretty unsuccessful, too. In fact, there was a POLST in one case, a New York case, and the court refused to enforce it, saying that the patient was Catholic, and therefore the POLST didn't need to be enforced. It was very, very poorly worded and poorly reasoned decision. I don't think there's going to be much litigation about POLSTs. If we can look at advanced directives, we know there has been very, very few cases brought about enforcing advanced directives. A couple of other comments that I want to make of sort of a broader nature. Yesterday, there was some discussion about the President's Commission report. And this is the 30th anniversary of the report, Decisions to Forego Life-Sustaining Treatment. I'm surprised there hasn't been a little bit of hoopla about that, but there hasn't been. I was on the staff when that report was written and came out, so I know a bit about it, but I think more importantly, I think it has had a tremendous influence on the law. And I think the law has had a tremendous influence on clinical practice. And I think clinical practice has had a tremendous influence on the law and on public opinion. And it's all been an iterative process, feedback and reinforcement over the last 30 years in the wake of the President's Commission report. The case law has had a tremendous influence, as I've said. It doesn't mean that everybody's following it precisely. Rather, I think it sets the contours of end-of-life decision-making. It's gotten patients involved. The President's Commission report, the case law, the statutes. It's gotten families involved. It's gotten us to understand that patients' wishes are central. I'm not saying they should be, but that's the consensus that has developed. And a whole generation or two, or maybe three, of doctors have been trained with these ideas in mind. And I think it's also had an influence on older doctors as well who were trained beforehand. Now, there was some talk about whether the pendulum had swung too far in favor of autonomy and not enough in favor of doing what's best for the patient. And I think that is a serious issue that requires consideration. There's lots of data about POLST and how it operates, but I wonder if we're asking the right questions. I have some skepticism. I like to get it right, and I think POLST is an effort to get it right, but I'm also somewhat of a perpetual skeptic. I think there's two problems with POLST. One is what I would call the authenticity problem. It may be that there's lots of POLSTs out there and they're being followed, but do they reflect the patient's wishes, and do they reflect the patient's needs? And a lot of them are, I think, as Rebecca indicated, hypothetical. That people are being asked, what would you like to do if? And then when the time comes, who knows if that if is what's best. Second is what I call the autonomy problem. And that is we've stressed autonomy an awful lot. And we failed, and to the point where, of course, now that patients, families sometimes demand treatment that's quite inappropriate. We haven't looked to the resources issue. We haven't looked to questions of best interest, of what's in a patient's best interest. We haven't looked to the issue, nobody's wanted to touch it, of what's in a family's best interest, or, and maybe I'll get pilloried for saying this, what's in society's best interest. Because we can't lose sight, I think, of the fact that what's going on here is that we're spending other people's money. Okay. To me, those are some of the biggest end-of-life questions. POLST is a useful, desirable mechanism, but it's certainly got its limitations, just as advanced directive statutes and informed consent and all other kinds of mechanisms for getting patients involved in decision-making are. Thank you very much.